present the appeal on the patent issues, and with my Lord's permission, Milano Junior Mr. Austin will present the appeal on the IPEX costs issues, which are logically separate topics. My Lords, the case concerns ostomy bags, of which two types are an issue. Both are sold by the respondents as part of their ModaVi range, and one type is generally referred to as closed bags and the other as open bags. If my Lords have my skeleton to hand, there's an illustration on the first page of that. It's core bundle, tab 4, page 36. Yes. My Lords have it. There are larger reproductions elsewhere in the case papers, but this shows all the key points. The one on the left is generally referred to as a closed bag, and my Lords can see A and C mark a particular portion referred to in the case as the waist, and C and D refer to portions referred to as the lobes. The open bag, which is on the right, only has the waist. My Lords can see that marked A and B. Of course, the open bag, the one on the right, is normally closed in use when on the patients, and it's only drained to get rid of the contents and reuse the bag. Now, both types of bags were and are alleged to infringe the patent, which is the major issue. There was a major issue on validity below, involving what I would characterize a whole raft of attacks. There were 8 distinct prior art attacks at one time or another, as well as added matter. But my Lords only have to deal with one relatively narrow issue on validity, which is the Grundschwänzen anticipation. There never was any validity attack based solely on common general knowledge, nor were any aspects of the alleged common general knowledge ever pleaded, even when the case was still in the IPEC. As regards validity, the only validity issue is indeed lack of novelty of Claim 8 as granted. There is no dispute that Claim 8 as amended is novel and inventive. Now, the upshot of all that, my Lords, is that while the open and closed bags are both an issue on the appeal, the nature of the appeal with respect to each is different. Because in relation to closed bags, my clients, the appellants, won on every issue necessary for a finding of infringement of Claim 8 as amended, pursuant to the doctrine of equivalence, apart from the very last step of the analysis, which is referred to as Octavus 3, the third Octavus question. And the particular feature of the closed bags relied on for purpose of infringement of that claim are the lobes. Now, one point which is unusual about that part of the appeal is that the judge himself, with the agreement of both parties, gave permission to appeal on this ground. And by agreement of both parties, I refer to the judge's brief reasons, core bundle, page 154. Now, in relation to closed bags, we also and respectfully challenge the judge's conclusion in relation to normal infringement, i.e. not just the doctrine of equivalence. And we again rely on the lobes for that purpose. But of course, we don't need to win on that if we win on infringement pursuant to the doctrine of equivalence. It would merely be another route to the same legal conclusion. So the part of the appeal which relates to the closed bags only involves infringement, only involves third Octavus question, so far as the judgment is concerned, and our infringement argument only needs the lobes. Now, we would need to rely on the waist for the closed bags if we wanted to win on claims 5 and 20 as well as Claim 8. But if we win on Claim 8, we don't need to. These additional claims don't matter. So that's the closed bags. For the open bags, we do have to win on validity, and we do have to rely on the waist because there are no lobes on this one. So there are more issues in play on that part of the appeal, but there still is a substantial degree of overlap. For instance, the normal interpretation of the claims overlaps, and the inventive concept overlaps between the two aspects. And of course, both of these topics have to be assessed without reference to the alleged infringement. both topics being normal interpretation and inventive concept. That is indeed one of my criticisms of the Respondent's approach. My Lords, the two documents of most importance are the patent and the judgment. And I propose to start with the patent before going to the judgment. My Lords will find it in the supplemental bundle, right at the beginning, page 1, tab 1. My Lords will note the title is an ostomy appliance. As the judge explains, no need to look at it now, but it was judgment paras 29 to 32. This is the most general term. There are in fact three types of ostomy bags. Colostomy bags, which are generally for the more solid waste. Urostomy bags, mainly for urine, and ileostomy waste, which is between the two in terms of consistency. And when we refer to more solid waste, it is in fact largely human feces, so it's not a rigid solid. Now, I can go to page 10 of the bundle, which is not numbered, but it is in fact the first page of the description of the patent. And my Lord will note pages 9 to 10, the invention relates to ostomy appliances in particular, but not exclusively. The invention relates to closed ostomy appliances, so that would be for the more solid waste. And the next paragraph, I'll just read it out. Ostomy appliances are well known. When an ostomy appliance becomes fuller, it tends to start to bulge outwardly. Such outward bulging is unsightly, which may cause a user embarrassment. Also, the collection of waste in the bottom of the appliance can cause a user discomfort, as it tends to pull at the top of a wafer, which connects the appliance to a user. This can lead to the wafer detaching, which is clearly undesirable. Now, there's no suggestion these problems were unknown, and there's still no suggestion to that effect. Now, a number of points to observe before going on. To begin with, of course, the ostomy bag is flat against the user's skin because it's empty. And as it begins to fill, it will inevitably start to bulge compared to a flat bag because it's filling with either solid or fluid material. And it's that unsightly nature of the bulging that causes the user embarrassment because it makes it more obvious the user is in fact wearing an ostomy bag. And the second distinct point here mentioned is the user discomfort due to the collection of waste at the bottom of the appliance. The heavier the bottom of the bag, the more it pulls at the top. And the top is where it's connected to the user via what's called a wafer. And this second problem of too much weight at the bottom can in turn lead to a third problem, which is that of the wafer detaching, which is described with some understatement as clearly undesirable. So these are the known problems. Line 19, it states the present invention seeks to address these problems. No other problems are identified. There is then a series of consistory clauses which track the relevant claims. No need to read these now because we'll read the relevant claims later. What I would like to go to is page 20 of the bundle, page 11 of the original. And towards the bottom of this page, line 21, embodiments will now be described by way of example only with reference to the accompanying drawing, of which there's a number of figures. So this makes it clear that embodiments will be described by way of example only. So it's clear that the drawing, or rather the figures which make up the drawing, are just examples of the invention. Now, to start with figure 1, my lords might find it helpful to have one figure on page 21 of the bundle and the other at page 4, which actually is figure 1. As noted at the bottom of page 21 of the bundle, figure 1 shows a closed bag in solid lines, but dotted lines at the bottom, indicated generally by 50, show how one could modify it to provide an outlet 50 and hence create an open or drainable bag. The patent doesn't go into details about the closure mechanism if it's a drainable bag. So now we've got figure 1 in front of us. I'd like to, all we needed page 21 for was just to establish what figure 1 is, the front view. Moving on to page 22, this describes figure 1. Most of the description is non-controversial. For instance, at the top of the page, it refers to the first wall 12, including a stoma receiving opening 16, through which a stoma is received, and 16 is the bit shown in circle, a dotted circle, a dash circle rather, on page 4. And then it mentions the use of a connection member or flange, which may, for instance, be a hydrocolloid wafer. That's not particularly important. I would draw my Lord's attention to line 18. Advantageously, the appliance 10 includes additional weld portions, meaning to the additional to the peripheral weld which connects the first and second walls 12-14 to each other. In the present embodiment, the appliance includes 4 such additional weld portions, 2 on each side, and these are weld portions 2028 on the left and 2230 on the right. And if my Lord return to page 4, the peripheral weld is shown in what might call tram lines going all the way around, but the weld portions 20, 28 identified on the left, and 22, 30 are identified on the right. Now, reading on page 23 of the bundle, page 14 of the original, there's some description about where the weld portions are positioned. At line 7, it says each weld portion 20, 22, 28, 30 extends away from the periphery 15 of the appliance 10 and downwardly towards the bottom of the appliance 10. The weld portions 20 and 22 are positioned at least partly below the stoma receiving opening 16. Pausing here, although the skilled reader would show that actually in figure 1 the weld portions are noticeably below 16. But they could go higher, provided, as the text says, they're positioned at least partly below the stoma receiving opening. Now, lines, there's a further description on this page describing the details of these particular weld portions and where they're positioned. But I draw my Lord's attention to page 24 of the bundle, page 15 of the original, where it says the weld portions 20, 22, 28, 30 are highly advantageous in preventing bulging of the appliance 10 during use when it contains waste. The weld portions, then numbered, ensure the force acting on the appliance as a result of the waste is distributed relatively evenly along the length of the appliance 10. This helps prevent the appliance 10 from pulling on the top of the connection member 17. Now, a number of points about this passage. Firstly, the weld portions are not merely advantageous, but highly advantageous. Secondly, it's true this appears in a section describing the embodiments by way of example only. That was the words we saw on internal page 11, bundle page 20. But there is no other section in the patent which refers to bulging at all, let alone how to prevent it. Nor is there any other section in the patent which refers to the appliance pulling on the top of the connection member, i.e. the wafer, or indeed refers to the appliance pulling anything. And we would say that the skilled addressee would reasonably deduce that this passage is intended to be a general description of how the patent addresses the problems at which it is addressed. Now, the next paragraph deals with the location of the weld portions. And just to summarise, it essentially says they might be connected to the peripheral weld 15 and acts as an extension or continuation of it. That's lines 14 to 15. Or they may not be connected, such there is a space in between. But returning to the discussion of the weld portions, the third full paragraph of the page, the weld portions are each elongate with upper edges which are generally arcuate, although they could be curvilinear, i.e. a curved line.
What does arcuate mean?
I would just imagine not a mathematical precision tense, but following some sort of arc.
Yes, I see. As opposed to a curve.
Yes, well, curvilinear just means a curved line.
Yes.
And arcuate, I think, might be something a bit more precise.
Mathematical.
Yes. And then there's a reference to the end of the weld portions, which could be either curved or rounded. But then we have a little bit more teaching from the patent with respect to figures 3 and 4. And if my lords could open, we'll keep this page open, page 24 of the bundle, and also page 6. This is figures 3 and 4. And just looking at figure 3, we see that the top edges of both upper and lower weld portions, they're not identical, but there is a similarity in the sense that as it curves away from the peripheral weld, going from right to left, the upper edge, it starts off as vertical in both figures 3 and 4, then it curves through either an arc or a curved line, and then it becomes straighter again. So that's the shape of the upper edge, and it is different as between the top and bottom weld portions shown in figures 3 and 4. Now, it's not stated here, but we submit that skilled addressee would appreciate that the shape of the upper edge does matter, whereas the shape of the lower edge does not. And I'll say more about that later. Returning to the patent, there is a lot of description of figures 3 and 4, hopefully saying more or less what I just said more briefly. I'm going to the bottom of page 25 of the bundle. It says, in use, waste is permitted to pass from the stoma receiving opening 16 between the free ends of the weld portions directly downwardly to a bottom of the waste collecting cavity 18, and in the case of a drainable appliance, directly to the outlet 50. Now, much of the rest of the patent goes into detail about matters such as the angles which could be used for the weld portions. As we'll see later, the claims relied on don't refer to any specific angles. The only other point I would wish to draw my Lord's attention is a section on page 28 of the bundle, para 19 of the original. This is a further description of figures 3 and 4. It says, as can be seen from figures 3 and 4, the weld portions 20 and 22 are a different shape from the weld portions 28 and 30. It will also be seen from those figures the weld portions 20 and 22 are smaller in area, i.e. surface area of the weld, than the area of the weld portions 28 and 30. Their shapes and area size have been configured to provide improved resistance to sagging of the appliance 10 during use. And this is the only reference to sagging in the patent. Now, as noted by the judge in his judgment, we'll get there in a moment, it's judgment 36, the parties agreed what the terms bulging and sagging meant prior to the service of expert reports. In fact, the extent of agreement went further because the parties also agreed about what was meant by the force acting on the appliance as a result of the waste being distributed relatively evenly along the length of the appliance, which was the other thing mentioned on page 1 of the patent. Now, I can show my lords the extent of that agreement. If my lords go to bundle tab 3, it's the same bundle we've got. And page 63. And the background to this was that my clients were ordered by Mr. Justice Mead to give notice in writing of our understanding of the terms bulging, sagging, and distribution of force acting on the appliance as a result of waste. That's noted in the first couple of paragraphs. And lower hole punch, bulging means to swell outwards. Don't need to read the rest of that. Sagging means to bulge in a generally downward direction. And then the distribution of force acting on the appliance as a result of the waste refers to the relative strain experienced by the ostomy bag in different locations caused by the accumulation of waste inside the bag. For instance, the patent explains at page 1, lines 14 to 17, that if waste collects in the bottom of the ostomy bag, this tends to pull at the top of the wafer, which connects the bag to the user, thereby causing discomfort to the user and can lead to the wafer detaching. This is an example of uneven force distribution along the length of the appliance. Instead, such force may be distributed relatively evenly by channeling contents to the centre of the collecting bag. And what happened thereafter was that at a later hearing, the defendant was ordered to set out its understanding, and that's at the next tab. Tab 4 in a sub-bundle, defendant's revised understanding of terms. And if my lords go to page 66, as far as bulging is concerned, 6, the defendant doesn't believe its construction terms materially different. Sagging, 9, defendant doesn't believe its construction terms materially different. But they did have 2 objections to the uneven distribution of force. Para 10, their position was that force is meaningless. What was actually meant by page 15 of the patent is that waste, that's ST, is distributed relatively evenly along the length of the appliance. We agree with that. And next page, page 67. Again, bulging, sagging, and even distribution of force. The defendant proposed addition of wording in square brackets that it's the distribution of force acting in the appliance as also the waste refers to the relative strain experienced by the ostomy bag in different locations along the length of the bag caused by the accumulation of waste. And again, that's agreed. That was what always was agreed. It was implicit. So by this stage,
bulging really mean very much. I mean, it seems just to mean that the bag is being filled up, because it seems to be saying a movement in any direction of the bag as a result of material entering it.
yes, but there's a difference between well, uneven bulging and even bulging. We'll see when we get there. Yes. But my lord is absolutely right. Bulging means the bag is filling up, as it has to.
Every bag fills up.
Yes.
Every bag bulges, in that sense.
Yes, but there's different types of bulging. There's bulging which is quite pronounced bulging, which will be noticeable under clothing. And what we say is the more regular bulging in the patent is not as noticeable under clothing.
So it's really about evenness.
Yes. Yes. But just to recap where we've got to, now read the patent, reached a common understanding on bulging, sagging, and even distribution of weight along the length of the bag. There was also common ground between the experts as to how the weld portions achieve these results. What's not entirely clear from the judgment is whether the judge appreciated it was agreed, but it was. Now, the learned friend skeleton has a very useful diagram which appeared in evidence of the law. And if my lords go to core bundle tab 4, sorry, that's the wrong reference, 5. Page 72. This is a section of learned friend's argument. What is the purpose of the weld portions? And para 53 is learned friend's wording, of course. As we've already noted, whilst the patent explains what it wants to achieve, it does not explain the mechanism by which the taught additional weld portions to do this. The judge therefore had to rely on the evidence before him to assess the additional weld portions work. Note this does not appear to be in dispute. And it's right, never was in dispute. We adopted Ms. Anderson's succinct explanation, which is essentially, as one sees, the output is forced up rather than out, which reduces the irregular bulging, I think that was my lord's question, and achieving a flatter, more uniform profile. Forcing output up limits the amount of output which can accumulate at the bottom of the bag, keeping the centre of gravity of the output closer to the user's body, which reduces the moment of the output and the downwards force on the front of the bag, thus reducing the deformation top of the bag, or sagging. Because sagging is reduced, this in turn reduces pooling on the top of the wafer. And the mechanism, if one always look at the bottom diagram on the left, bottom of the page, the diagram on the left, that's actually taken from Anderson 1, paragraph 151, figure F. I don't think we need to go there, but it's Bundle 6, page 102. And this refers to what's described as, quotes, more solid waste. That's Herz's words, more solid. Because if it was more liquid waste, the grey would just spread to the outside. And that's another point made in that figure F. And Mr. Bree was our expert. He did agree with this paragraph. I don't think we need to go there. It's Bree 2, paragraph 6, Bundle 7, page 120. Now, what's shown in this diagram on the left of this page is the weld portions prevents the waste from filling the whole of the bottom of the bag. And I say that because the grey area doesn't go right to the edges in the bottom part of the bag. Because that waste has to go somewhere, it goes, as Ms. Anderson says, up rather than out. So it goes above the top of the weld portion. The circle, of course, that's the opening. That's where it all comes in. Now, it's in this way that the weld portions reduce the irregular bulging and sagging, and there is the more even distribution of weight and therefore force along the length of the bag, which reduces pulling on the top of the wafer, and that's agreed. There's no dispute about it. I would ask my Lord to disregard the picture on the right, though. Firstly, because it's not very clear, but secondly, because that comes from experiments done on my client's commercial product, which isn't an issue, and it's not one of the experiments referred to in the judgment. I will refer, my Lords, to the experiments in the judgment separately. Now, one last point about how the weld portions work, and we can still keep this diagram on page 72 open. So far as the user is concerned, what matters is where the waste sits in the bag when it's attached to them, which is what's shown in this diagram. But it's important in our submission to think about how this position has come about. And we say it's not complicated. The waste can accumulate along the centre line, as shown in this diagram, for two reasons. First, because it fell straight down from the stoma opening, which is the dark blue circle. And it might do that if the bag is vertical in the user's body when the waste was expelled from his or her body, because it goes through various tubes and filters and then emerges through that dark blue circle. So it might fall straight down there. But secondly, the other reason why the waste can accumulate along the centre line is, we say, is because it was directed there by the upper edge of the weld portions. For instance, if the user was sitting down or doing something when the waste was expelled from his or her body, the bag wasn't vertical, then in that case it would have been directed away from the periphery and towards the vertical central line by the weld portion, and in particular by the upper edge of the weld portion. Now, these, we would say, are principles of very elementary mechanics. And two further points, we say, would be appreciated by the skilled addressee as being very clear. First, only the upper edges of the weld portions matter for purpose of directing the waste away from the periphery and towards the centre. The lower edges of the weld portions don't matter. And secondly, it would be undesirable for the upper edge of the weld portion to point upwards as one moves from the periphery of the bag to the end of the weld portion, since doing so would trap the waste in the wrong place. Now, that principle might be obvious anyway, but there's a diagram in the bundle, which I'll just show my Lords. It's sub-bundle, tab 7, page 119. And sub-bundle, tab 7, page 119. It's a diagram showing a weld where the upper edge actually goes upwards, and that traps waste in the region shown by X, which is at the periphery, which is exactly the opposite of what you want to achieve. That would mean that the waste would be forced back out to the periphery rather than up the centre line. Now, my own friend says that this idea of waste sliding down the top edge is never mentioned in the patent, and he's right about that. It's not mentioned in the patent, but neither was Ms. Anderson's explanation mentioned in the patent, nor a diagram, and there's no dispute about any of that. My learned friend says this idea of waste sliding down the top edge is somehow excluded from the case. That's not correct. I just showed, my lords, the explanation of our case, which you're all to set out, to which my learned friend responded. That uses the word channeling. No objection was taken to it as being unarguable in the defendant's revised understanding of terms. They only had two qualifications, that it should refer to waste, not force, and it should make explicit that was considered to be implicit. Now, returning to Ms. Anderson's diagram, just to close off on that, it's back in the core bundle, page 72. The mechanism shown in that diagram was sometimes referred to as narrowing the bag. And it's easy to see what's meant by that, because the solid waste occupies the central area of the bag rather than spreading all the way to the left and right margins. So it is a convenient shorthand to use, but it's not literally accurate because the width of the bag itself, meaning from left peripheral weld to the right peripheral weld, isn't changed just because you added the weld portions. It's still at the same width. And if the waste was more fluid, it would flow into these regions. So it's a useful shorthand, but of course literally making the bag narrower, making it narrower would make the bag less desirable because it would reduce the volume of the bag and it would hold less, need to be changed more often. So narrowing is a useful concept provided one realises it's not literal, and if taken literally would be undesirable. Now, my lords, I was going to come to the judgment, and I'm going to start at the beginning of it, partly because the points made there are important, but also to say going backwards and forwards. And if my lords turn to core bundle tab 9, or my lords may have it loose, the only points in the beginning section are as follows. Paragraph 6, the judge makes a point already made to my lords, patent addresses.
Sorry, can you just give us a quick route map?
Yes.
Because of course we have all read the judgment,
yes,
as well as the
yes,
scales and arguments. So I think we're reasonably conscious of the shape of it, if I can put
yes,
it like that. I'm getting the impression, maybe wrongly, that you're proposing to take us through it from beginning to end. I'm not sure that's going to be very
I'm not doing that, no. Only bits that I think are particularly relevant. I won't be reading the whole thing. But I'll certainly do that as quickly as I can, because I appreciate my lords have read it. Is the key document in the case.
Right, okay.
So all I was getting out of this introduction section, para 6, the patent addresses known problems with ostomy bags unsightly bulging and waste. So as I said, it was a known problem. Judge finds that. So far as para 9 and 10 are concerned, the point here is that one of the learned friend's points, which we'd say is not relevant anyway, but he refers to what's called the C-shaped weld. Now that is something which is at the top of the bag, and we say, well, whether that has an effect has nothing to do with whether other parts of the bag have an effect. But it's important to note, as the judge notes, line 3 and 10, Pelican's expert witness didn't even realise what the C-shaped weld was for, or rather, to be more accurate, she didn't realise that the C-shaped weld helped prevent the bag bulging. And then Mr. Mahood, who was cross-examined at the PPD, was distinctly uncomfortable, treated the evidence with caution. We don't need to come back to his evidence, the judge didn't rely on any of that. Para 13, the role of the PPD was limited, we agree with that. And then Econ, to which I'll come back to, speaks for itself. The judge also held that both experts were doing their best to assist the court. That's all we need to worry about in that section. So far as the common general knowledge section is concerned, there's only really one point on here, and that's about figure of 8 bags. The sensible learned friend wants to rely on it. If one looks at the common general knowledge section, 28 to 31 is explaining about 3 different types of ostomy bags and so forth. Judgment 29, shape 9 is a figure of 8 shape, and various commercial products are of this shape. We can see what the judge means there. But at judgment 35, paragraph 35, we see the findings of fact the judge made about that, which are not nearly as extensive as my learned friend seems to think. All the findings made by the judge about bag 9, one can see from judgment 35. The bag is a waste, and that has an effect on how the bag will fill, yes. And then he rejects our submission that only the specific figure of 8 bag was common general knowledge. He rejects that. But then the last 3 lines are the extent of the findings that were made about it. Mr. Bree accepted the waste would make the bag smaller and that a larger bag with a waste could be designed. Well, yes. Miss Anderson said a waste would influence the width of the bag and so the volume available to correct waste. Yes. But there are no findings to the effect that the waste has anything to do with preventing bulging, sagging, or an uneven distribution of force. Nor is there any suggestion that lobes form part of the common general knowledge. It was just the waste. And my learned friend's respondent's notice doesn't criticise the judge's findings on common general knowledge, nor does it invite this court to make findings about common general knowledge which the judge did not make. So the only finding was that figure 8 bags existed, not that they had any particular relevance. Now the next section of the judge is the patent, and I don't need to spend time on this because I've taken my lords through the patent. If I could pick it up at para 47. In our reading of the judgment, all the judge is literally saying is what the patent does or doesn't say. The patent does not explain what forces are acting on the appliance or how the welds work to achieve the result claimed. Yes, it doesn't say that. It appears the inclusion of welds will narrow the bag. It does not explain whether that is...
Well, of course, what he says there is a little odd, because he's just quoted page 15, lines 4 to 9 in the previous paragraph, which say that the weld portions ensure that the force acting on the appliance as a result of the waste is distributed evenly along the length of the appliance. So, in context, he must mean not that there's no explanation, but that there's nothing more than what he's just quoted.
Yes, it must be that. He must be saying there's nothing more. And he says that it appears the inclusion of the welds will narrow the bag. As I said, that's not words in the patent. But moving on to para 49, he says there is no description of how the weld portions work when the bag is filling in use or what effect they have. Again, that's true. But then paras 50 to 52, he says at trial the experts gave some explanations of how the structure of the bag might work in practice. It's not clear with respect to the judge whether they actually appreciated there was no dispute about how the structure of the bag actually worked. Miss Anderson talks about higher the centre of gravity of the waste in the vertical direction. And Mr. Bree describes it as reducing a pendulum effect, but these are just 2 different ways of describing the same thing. If you move the centre of gravity up, you're reducing the pendulum effect at the bottom. So it's, as I say, our submission here is, the judge says, he concludes in section 52, even with these explanations, performance of an appliance of the invention is relative. It's stated in the abstract, it's difficult to disagree, it's relative, but it begs the question, relative to what? And the answer in our submission must be relative to an appliance which does not have the well portions. And then that would be true of many patents. It's relative to something which doesn't have the claimed feature. So, as we respectfully say, it's not quite clear whether the judge approached the claims on the basis there was this agreed technical explanation, that the experts were saying the same thing, or whether he thought there was some dispute about it, because he doesn't in fact say that it was a common technical understanding. Anyway, then we come to the claims, and the judge has set out claims 5, 8 and 18 to 20. And lawyers will note that claim 20 actually depends on 19, which depends on 18. That's apparent from...
At the moment, I can't see that claim 20 is of any relevance to the appeal.
Well, that's certainly our view. We say we win or lose before we get there.
But
on claim 8.
We don't need to get into it, do we? Because you can't infringe claim 20 unless you infringe claim 8. If there's no infringement of claim 8, therefore it doesn't arise. I don't understand there to be any dispute that if claim 8 is infringed, so is claim 20. And there's no issue about independent validity.
Yes. Well,
So,
my Lord, that was,
in short, it's irrelevant.
well, my Lord, that was the point I was trying to make at the beginning. If we don't see that it's necessary either, there'll just be alternative and further routes to the same conclusion. As my Lord says, the validity argument centres around claim 8, not around claim 20. So yes, my Lord, I do agree.
Okay.
Now the judge, having set out the claims, he then comes to construction, which is in paras 58 to 62. And actually, it's really just 59 to 61, just these 3 paragraphs. Now, it is noteworthy in our submission that the judge, he doesn't remind himself on the law of normal interpretation of the claims at this stage of the judgment. He does do that later, to be fair, at Judgment 101. But that only appears after spending considerable time in the details of the infringement. And we say, well, that is important, because if the judge had reminded himself of the need to give the claims a purpose of construction, he would very likely have referred to the agreed technical explanation of how the well portions worked. But he didn't do that. On the contrary, the first substantive paragraph is Judgment 59. And the judge says twice here that the well can be either part of, additional to, the peripheral connection. That's line 3. And then the same point, in slightly different language, the last 2 lines. The well portion may form part of the peripheral connection, as shown in figure 1 of the patent, or be separate. So it's either part of it, or it's separate stroke additional.
And just relating that, he's related that to figure 1. So what does he mean by reference to figure 1?
I'm not sure actually. Yes, it may form part of the peripheral connection as shown in figure 1, or be separate.
Yes.
Absolutely.
Yeah. Yes.
But we'll see later, though, that's his construction. That's not the construction he applies when he gets to infringement. He applies a different construction. Now, Judgment 60 to 61 extends downwardly towards the bottom of the appliance. And he says, well, this means the weld points down. Now, let's look at the reasoning for that. The weld portions shown in the figures of the patent all point downwards in that way. Well, that's true, but they were only said to be an example. Para 61 is the main reasoning. But we'd respectfully criticise 61 in a number of respects. First of all, the first sentence, taken literally, doesn't seem to say very much. Salt submit that all the patent requires is the wells must slope downwards in a direction that's between the horizontal and the vertical. Well, if it's between the horizontal and the vertical, it obviously must slope downwards. But that doesn't accurately record our submission. If my lords go to our written closing submission below, bundle 13, page 192, there's a section on page 192 of the sub-bundle entitled "How Does the Patent Work?" This is taken from our closing submission. And paragraph 84, when we're discussing the weld portions, in practice this means that some part of the peripheral weld must be set at an angle so the waste inside the bag that would otherwise be heading down the sidewall is directed towards the centre of the bag. Therefore, the exposed upper edge of the peripheral weld portion must slope in a downwards direction and inwards from the periphery. So we were emphasising the exposed upper edge of the peripheral weld that had to slope downwards. We weren't saying what the judge records us as saying is that the welds must slope downwards. We were stressing the exposed upper edge. And it wasn't the only place we said it. We made a similar point at paragraph 113. This was dealing with this integer, about the weld portions extending downwardly. 113, third sentence, we say that what matters is the downward direction of the upper edge of the weld portion, which will be in contact with the waste. It must be able to direct the waste downwards due to its slope, regardless of the shape of the rest of the weld portion that sits below. So when it returns to judgment paragraph 61, the first sentence doesn't accurately summarise our submission. It was always the upper edge of the weld portion, not the welds. And then the judge says on, for example, it doesn't matter if the periphery of the bag itself simply changes direction to achieve that effect. The result is the waste is still directed downwards. Now he disagrees with that, but the reasons for disagreeing is he says the description requires the weld portion, which is different from the periphery. So he's gone for different rather than different or additional to have a downward direction, examples of which are shown in the figures. So he's back on the figures again, which are only examples. And then this last sentence is particularly puzzling. There's also an aspect of the invention which the welds are not required to extend downwards, but are placed substantially midway down the cavity. And that's not an aspect of any of the claims relied on.
But it is an aspect of the claims.
Yeah. He says there's also an aspect of the invention, and this section is each of the claims alleged to be infringed, paragraph 58. Well, then Fred will have a chance to make his points, but I don't believe that's an aspect of any of the claims alleged to be infringed.
So just to be clear, this paragraph, we get the weld portion which is different from the periphery.
59, yes.
Sorry, 61.
61, yes.
Says,
he said different, even though 2 paragraphs before he said it could be different or additional too.
Is that the point he's making there? Or is he just saying the weld portion is not the same thing as the periphery? It might be part of it.
Not the same thing as, possibly.
And
yes.
The point he seems to be making, as I read it, is to do with direction there. And he's saying you take the direction of the periphery as one thing, the direction of the weld portion is another thing. So he's not saying, he's not making the point, I suggest, that it's separate from. He's just saying it is a different thing from. It might be part of it, in the sense that they're connected to one another,
Yes.
but it's a different thing.
Well,
It's it would be a very odd thing for him suddenly to say it has to be that in all cases it is separate from the peripheral.
no,
Having just said the opposite.
yes, he's. Well, it could be that he's just talking about the figures, because the figures certainly show the weld portion as being something which is, quotes, different from the periphery, because they show it coming in. So perhaps he has that in mind.
except he says the description requires examples of which are shown in the figures.
Yes. He's not clear about which bit of the description he says has that requirement. I took my knowledge to the passage on page 15 of the patent, and that is, I say it's a general teaching, but that's also part of the examples. I think our overall point here is that he's failed to appreciate, the judge failed to appreciate our point about the upper edges being the important bit rather than the weld portion as a whole. because he seems to think, in this paragraph, he only seems to treat the weld portions as a whole rather than focusing on the upper edges.
Just help me a bit on that. You explained well what you've got in mind is different from just narrowing the bag.
Yes.
You narrow the bag, you limit the capacity of the bag. Does that imply there has to be something protruding? Because otherwise, are you not just narrowing the bag?
Well, there has to be something which we would say which directs the waste, because the WASTE, because otherwise you get the problem of bulging and sagging and uneven distribution of force, and that's what you're trying to avoid. So there has to be something which acts to reduce that effect. And we say it is the diagram to which I show my lords. It's the way in which they direct the waste to the centre.
And just to be clear, it's something, or not, that will have a lower edge, because otherwise you are simply narrowing the bag.
Yes, I follow what Lord says. Yes, exactly. Because otherwise you're just taking it in and reducing volume to no purpose.
Yeah. Well, I suppose you are doing it to a purpose because you're achieving the same
Yes,
effect.
exactly. Yeah,
You're doing it at the expense of the capacity of the bag.
correct. I agree.
Yeah.
Are you going to come back to the wording of the claims and make further submissions about all of this?
Well, I'm going to come back
And what's
to
meant by weld portion and upper
yes.
slope and, sorry, upper edge and bottom edge and so on?
Well, I'm going to come back to the judge's section on normal infringement. Yes. But if my lord is saying, when I come back to construction, no, I'm not coming back to it. So welcome further questions.
All right. When one's construing the particular claim, is it legitimate to look at the wording of the other claims just as part of the whole document?
That's one of the points on inventive concepts that my learned friend has.
But on construction?
Yes, our answer is no. It's not legitimate. You've got one claim. It's not legitimate to look at other claims.
Even the way they're phrased and
Yes.
worded?
We recognise a limited exception to that if they're subsidiary, if one expressly depends on the other, because sometimes you can draw inferences. If you know one is a subset of the other, you can perhaps make deduction. That's about the car with square wheels. That sort of thing.
All right, can I just focus the question a bit more? If you look at page 31 of the supplemental bundle, and you may say this is an illegitimate process. If you look at a number of these claims, they talk about the weld portion.
Yes.
It's the concept which is used. And then in some of them, they specifically talk about the top edge and the bottom edge. So, for example, on 31 at 4, it says the weld portion includes a top edge and a bottom edge, and then it makes a point about the top and the bottom edge being generally parallel and are connected with a curved end. And so it's specific, so it's making a distinction, in other words, between the weld portion, which is the whole thing, as it were, and the top edge and the bottom edge. Now that, at least on one reading, might suggest that the weld portion is a thing with a top edge and a bottom edge, because it says so there.
Yes.
And it must be true in any case. But if you then come on to 5, which is one of the relevant claims, it doesn't say anything about the edges. It talks about the first weld portion extending away from the periphery of the appliance and downwardly towards the bottom of the appliance.
Yes.
Now that's not saying that the top edge points downwardly, sort of extends downwardly, to use the word of the claim. It says that the first weld portion extends downwardly towards the bottom of the appliance. And on one reading at least, that suggests that it's the whole of the weld portion which must point downwardly or extend downwardly rather than just the top edge.
Well, that's my friend's position.
No, but it's not just his submission, it's based on a
Yes.
reading of other parts of the patent, that's what I'm suggesting to you.
Yes.
And reading the document as a whole, it could be said that where the drafter wishes to make a point about the configuration of the top edge, the drafter specifically deals with that subject, whereas here the drafter is specifically dealing with the whole of the weld portion and saying that it has to extend downwardly.
I see my Lord's point, and there are claims. Claim 1, for instance, goes into points about edges. And I think we mentioned this in our skeleton. But we say it's just not of assistance to try and construe Claim 5 by reference to Claim 4. And that's because they're independent. So they're either saying the same thing or else they're not saying the same thing. But if they were, this goes to one of the points later in the case, but if the meaning of Claim 4 had an impact on the meaning of Claim 5, it would seem to follow that if Claim 4 wasn't there, or you deleted it or amended it, then Claim 5 would change its own meaning, even though Claim 5 itself never actually changes. And we would say that's not the correct approach.
But is it not right to read the whole document as well?
It is, but when one reads the whole document, one sees, well, there are different claims here. They're independent claims. And we're focused on 5, 8 and 20, particularly 5 and 8. And we say you look at them in isolation of the other claims. You read it in the context of the whole document, in particular the context of the description, absolutely. But we don't see how one claim can alter the effect of other claims. And even if it did, which way would that go? Which one trumps the other? Would one say that, oh, well, if you've got two claims, one which talks about downwardly and one which doesn't, downwardly doesn't matter then to Claim 5? In other words, which wins of Claims 4 and 5 once you start putting them in competition with each other? But our short answer is to say, no, we don't say it's relevant to look at other independent claims.
Right. Now I can ask you another question,
Yes.
because it's still about interpretation. This time, if you go to 28, page 28, which is talking about some of the figures 3 and 4, it talks about the weld portion, so that seems to be the whole thing, not just the top or bottom edge of it, has an axis which extends lengthways thereof substantially midway there through, and then there's an angle, preferably less than 90 degrees, and that's based on figure 3. Now, this is all part of the description, obviously,
Yes.
but it's a way of understanding what's meant by the direction of the weld portion taken as a whole. In other words, you come up with an axis which runs substantially midway through it. See what the angle of that is, and that tells you what the direction of the weld portion taken as a whole is.
Well, it certainly describes what's shown in figure 3 and 4, but the word axis isn't used in Claim 5. It is used in other claims. And I noticed that Claim 22 on page 37, that uses the reference to an axis B. But that's just a subsidiary claim. That wouldn't tell you what Claim 5 meant. It would just tell you this is one of the things within Claim 5 being a preceding claim.
Right, but you've just said you shouldn't look at the other claims when trying to construe the particular claim. So just sticking with 5.
Well, say it's safe that as a general proposition, claims that are dependent on whether are taken to be
Yes.
nested. So generally speaking, the presumption is that the independent claim will be broadest, And as you bring in additional features, it narrows it. And therefore, a dependent claim that has an axis feature in it will be narrower as a matter of principle than an independent claim that doesn't have that feature.
Precisely. That's the point I was trying to make, of not doing it as well as my lord.
But going back to 5, is the fact that in some of these drawings there is this idea of an angle of the weld portion, does that assist in the interpretation of what's meant by those words, the weld portion extending downwardly towards the bottom of the appliance?
Well, not particularly, because the angle is shown as alpha in figure 3 and theta in figure 4. But that's just interesting fact. It has this angle. There's nothing in claim 5, or indeed I think in any of the claims, that requires there to be any particular angle.
Can I just explore possibly a similar subject for a moment? If you go back to figure 1, you see fingers.
Yes.
In each case. Just so I understand your case, you say there need not be a finger.
Correct.
So rather, if you take, say, 20, there would be a downward slope, because otherwise you get something trapped.
Yes.
But then on your case, you could drop vertically from, so to speak, the end of the finger to the periphery elsewhere.
Well, yes, you could. You'd reduce the volume, but yes.
Yes. And so actually you would be achieving a narrowing of the bag.
Yes,
below
which is
the no longer finger.
yes.
And that's your case.
Yes.
Yes.
So, I mean, that precisely is our case. We say it's the upper edge that matters. And it's the upper edge that has to extend downwardly, not the whole of the finger. Sorry, when I say the whole of the finger, I meant the whole of the weld portion.
And just pursuing my law's point again, earlier in this document we get lots about upper and lower edges.
Yes.
So going back from 10, 11, so on. But that's not determinative.
No, I think...
Or doesn't matter at all.
I might get this wrong, but I rather think the first aspect of the invention, pages 10, 11, I suspect that maps onto claim 1.
Yes, that's it.
Generally speaking, these will map onto either a claim or a subsidiary feature.
Yes.
But these are separate claims to which that
Yes.
detail matters.
Yeah.
I think I rounded off. This may have prompted my Lord, not Justice Miles' question, but the last sentence of para 61. As I say, we say that's wording which doesn't appear in any of the relevant claims. And furthermore, the judge doesn't explain what he does with that. He's observing there's an aspect of the invention which the welds are not required to extend downwardly, but are placed substantially midway down the cavity. But so what? What conclusion follows from that? So at any rate, on this we say that paragraph 59 was correct. It's either part or additional to, but we respectfully criticise the judge's view about extends downwardly. Now, the structure of the judgment then goes into details of the infringement before considering the inventive concept. And I'm going to deal with the inventive concept first, because this goes to the Octavius questions. Now, the judge starts dealing with this at para 102. Where he sets out the Supreme Court's decision at Octavius and Lilly. He actually sets out para 1, although this court has reformulated para 1 in the next case. But anyway, he sets out the Octavius and Lilly original 3 questions, always referred to as question 1, 2, 3, because it's simpler than trying to remember the full wording, but question 1, substantially the same result, substantially the same way as the invention, I invented concept within patent. And then in para 103, he's quoted part of Lord Kitchen's judgment from Icecape case. And he says that as far as the first improver question, the court must focus on the problem underlying the invention, the inventive core or the inventive concept. Now, I would respectfully say there's just a little bit more assistance my Lord might get from the Icecape decision. In particular, it reformulates the question the judge has set out in 102 and makes an important point about Octavius 3. So, could I invite my Lords to go to authorities, tab 11. I'm sure my Lord Justice Arnold is very familiar with this decision.
Other members of the court may not.
Other members of the court may not have the same degree of familiarity. Yes,
I think that's a fair assumption, Mr. Counsel.
Thank you very much. This was a case of this court, and Lord Kitchen had just been appointed to the Supreme Court, but he finished off this case in the Court of Appeal. That's why it says Lord Kitchen. And don't need to read all of it. The passage I was going to pick up, well, let's go to paragraph 55. On page 316. Now, the only point about para 55 to 57 is that's what's called the old law under Catney, House of Lords decision. But picking it up in para 58, what Lord Kitchen notes is the position remains settled until the decision of the Supreme Court in Octavius. And then I'm going to read out the rest of that paragraph, because I'd like to go to the next paragraph to say that 59 is, in my view, clear that this approach is markedly different from that which the courts in this country have adopted since Catney. But Octavius did make a change. Not just a change, it's markedly different. And then paragraph 60, Lord Kitchen sets out Lord Newberger's speech. But says towards the end of paragraph 60, again this is Lord Kitchen, so I have no doubt that despite Lord Newberger's use of the term literal in considering issue 1, to which we'll come in a moment, issue 1 involves purpose of interpretation. Now that's well established. There's also reference to Lord Justice Arnold in first instance. So question 1 is purpose of involves purpose of interpretation. Paragraph 62, at the bottom of the page, this is the passage which the court, the judge at first instance in this case, does cite. There's 3 different forms of words used here: the problem underlying the invention, the inventive core, and the inventive concept. The case law treats these as synonymous, but tends to use the word inventive concept. And that's the basis for the first improver question. And then so far as the third improver question is concerned, Lord Kitchen emphasised a point made by Lord Newberger and Octavius. If we'll also look at 64.2, Roman 2, in considering the third question, the fact that the language of the claim does not, on any sensible reading, cover the variant is certainly not enough to justify holding the patentee doesn't satisfy the third question. Now, we'll see the importance of that when we come later, but when considering the doctrine of equivalence, it is not an answer to say the language of the claim doesn't, on any sensible reading, cover the variant. That is definitely not enough. Lord Newberger says that, and Lord Kitchen says so as well. And then we have those 3 reformulated questions on page 60, sorry, paragraph 66, next page 319. And what's happened here is Lord Kitchen has reformulated the tests, and the big change is, instead of literal meaning for the first question, that's 66.2a, it's the normal meaning of the relevant claims of the patent, and then sets out the remainder of it. And of course, the patentee has to establish that the answer to questions A and B are yes, and the third one is no. So yes, it does achieve substantial results in substantially the same way. Yes, it would also be obvious to the person skilled in the art knowing the variant achieves substantially the same result as the invention that does so in substantially the same way. Then third is strict compliance. The patentee has to show that strict compliance is not intended. Now, we always look at the point about the next paragraph about the file wrapper. Next point I wish to draw Lord's attention is paragraph 74, and this is where Lord Kitchen considers the third actavis question. And again, he says in terms, 4 lines down, here I must have in mind that the fact the language of the claim doesn't cover the variant is certainly not enough to justify holding that iScape doesn't satisfy this question. The reason I keep emphasising this is the judge in first instance in this case doesn't mention this principle, and we say it's fundamental. It's so fundamental, Lord Kitchen's mentioned it twice. And just finishing with what Lord Justice Floyd said in the same case, only 2 points there. The Lords go to page 325. Quite a short judgment, generally agreeing with what Lord Kitchen said, just adding a few points. Para 97 notes that a few sentences down, the claims remain the starting point for subsequent analysis of variance. Absolutely, the claims remain the starting point. At 98, then considering the facts of the instant case, Lord Justice Floyd says at the end, there is nothing to suggest that the patentee regarded serious connection as essential in any relevant sense, given that the language of the claim alone is not to be taken to be sufficient to give rise to that inference. It's the same point again, the language of the claim alone doesn't answer actavis Q3. Now, finally, on authorities, I'd like to take the Lords to the judgment of Lord Justice Arnold, sitting at first instance, a case called Acabia. Quite a long decision, but there's only a few bits to which my Lord's attention is going to be drawn, and it's Authorities tab 4. And if my Lords go to page 74, my Lord Justice Arnold, as it still is, at para 416, points out that iScape was actually reformulated Lord Newey's original word. But as far as 120 is concerned, the only point in 120 is that...
Sorry, where are you?
Page 74 of Acabia, Authorities Bundle, tab 4, volume 1, tab 4.
Yeah.
I say 120, I meant 420, sorry.
Yes, that's, yeah.
Yes, the only point on 420, and I apologise for misreading, it's a very context-specific question. It depends on what the patent is and what the infringement is. It's not one that benefits from a great deal of more legal citation. Now, I say that, my own friend's got 5 propositions, and I want to say something about them. Now, what were the factors that Tavis 3 here? Well, pick it up at page 79. I'd actually like para 446, which is just before the highlighted section. In question 2, as my Lord observed, given the way in which question 2 has been formulated by the Supreme Court, there will rarely be scope for a negative answer. And no one's saying there's a point on actavis 2 in this case. Now, question 3, as Lord Newberger pointed out Actavis and Lilly, the answer to question 3 cannot be dictated by the fact that the variant does not fall within the wording of the claim, its normal interpretation, because otherwise there would be no point in answering the question. Absolutely, that's the key point. I might respectfully say so. And there were a number of reasons in this case, but they were all very specific to the facts of that case. For instance, there's a reference to the way claim 17A was drafted. There's a reference to amendment, the way it was amended, page 452. And going over the page, there was a reference to a principle called disclose but not claimed. Otherwise, if we disclose something and then very obviously don't claim it, that's a principle that might assist in Actavis Q3. And then there was the prosecution history on paragraph 459. But the only reason for going to this, really, was the analysis of question 3 should, in my submission, always start with the point made at 447. The fact it doesn't fall within the wording of the claim, a normal interpretation, can't be an answer. So now we go back to the judgment, and we see that the judgment actually, para 102, to the out-to-date version of the first question, not the reformulated question. And the judgment hasn't identified the important point of principle about Octavius Q3 either. It doesn't mention that later either. And we say that is an omission. Now, my learned friend, he does propose 5 principles in his skeleton of approaching inventive concept. It's the last 2 which are controversial. But if I just go through them.
Sorry, let me just remind myself where they are.
The 5 principles.
This is paragraph 16.
You can go to my answer. Yes, it is, yes. Paragraph 16 on page 65. Now, before starting, important to note, as is common ground, that the identification of the inventive concept was a question of law for the court, not a matter for witnesses. First, the starting point is the claim, yes. That was Lord Justice Floyd Nyscape. Recourse may be made to the description, but care is needed, yes, because, as we say in our skeleton in reply, Lord Hoffman and Kieran Amjad made the point that a patent may, for one reason or another, claim less than it teaches. Another point that is that sometimes comes up is the level of generality at which you answer the first Octavius question. And there's plenty of first instance authority, I'm not sure of this court, to establish that the level of generality is the claim itself. But that doesn't, of course, mean that the words of the claims themselves, and without more, answer the Octavius questions against the patentee. Because if that were the case, then what Lord Neuberger and Lord Kitchen and Lord Justice Floyd said would be wrong. So the level of generality of the claim is important, but the words of the claims don't answer the questions by themselves. Thirdly, my learned friend's proposition, identification must be carried out with the common general knowledge in mind. Yes, but that doesn't take you very far, because perhaps the inventive concept resides in a combination of features which are individually common general knowledge, or perhaps the inventive concept resides in a combination of features which are new and those which are common general knowledge. But certainly in this case, the judge's analysis of inventive concept doesn't refer to any findings he made on common general knowledge. So we don't see that point 3 goes anywhere. The 2 more controversial principles, my learned friends 4 and 5. Now, when he says that the inventive concept should be relatively easily ascertainable, he seems to say, well, as opposed to Byzantine complexity, and clearly no one's arguing for Byzantine complexity, that can't be right. And I'm not actually accused of that, my learned friend Skeleton. But to say it should be relatively easily ascertainable, well, relative to what? Should it be easier than applying the doctrine of purposive construction, or what's supposed to be easier then? But if this is a legal question for the court, why does it have to be, quotes, easier or more difficult than any other legal question for the court? It's not one for witnesses. Or if all my learned friend means is that there should be a reasonable degree of certainty for third parties, that's the basis on which the Octavius questions were developed in the first place. So it's one which is inherently taken into account. And the final point is, I think, the one I've been discussing with my Lord Justice Miles, about the court look at all the independent claims, not just those alleged to be infringed. We say it's not legitimate for purpose of construction, it's not legitimate for inventive concept either. Now, I already alluded to subsidiary claims, there is a role for that doctrine because, as Lord Justice Arnold explained, one's nested within the other and you can make some deductions. But even that process can't be taken too far, because in our skeleton at paragraph 25 we cite a well-known example given in Ultraframe and Eurocell. Claim 1 is a car, and Claim 2 is a car as claimed in Claim 1, wherein the wheels are round. Does that mean that Claim 1 covers a wheel with non-round wheels? Well, literally yes, but that's the over-meticulous verbal analysis which is deprecated. So even when they expressly relate to each other, there are limits to the principle.
So just to understand, if you take an individual claim, you construe that purposively, as you've explained, having regard to the wording, but also the purpose. Identifying the inventive concept is distinct from identifying what it means as a matter of language and purpose.
Yes, it's inventive concept, inventive core, problem underlying the invention.
But again, on your case, you're looking at the inventive concept in relation to that specific claim, not being helped by the teaching elsewhere in the passage or anything of that kind.
Correct. Now, there's one slight refinement. In the 5, 8 and 20, we say our variations on a theme. And a learned friend makes that point in, I believe, para 5 of a skeleton. It's a single theme with variations. And the variations don't relate to, well, para 8, claim 8, 2 well portions, claim 5 has got 4, and claim 20 has got more requirements still. So you can see that the single theme there, we would say, is the well portions. And the variations are the number of well portions and the relationship to each other.
But just to be clear, so suppose you construe claim 5, for the sake of this argument, as requiring fingers. Where do you extract a separate and wider inventive concept?
Well, claim 5 doesn't use the word fingers in the first
No,
place.
no, quite. So
yeah.
you don't accept that as a matter
Yes.
of construction. But supposing, as a matter of construction, it requires fingers,
Yes.
what would the wider inventive concept be? How do you get there in relation to that claim?
Oh, well, you have to consider the problem underlying the invention, the inventive core, and we've actually put forward an inventive concept that we say does take those things into account. I mean, the question of how does one get there, it's probably not one that has a straightforward answer, because it's very context specific. It's very specific to the patent in issue. You have to extract, well, what is the problem underlying this invention? What is the core invention? So if I was looking for anything more specific than that, it's quite difficult to see, well, what more could you say? The inventive core, I mean, that's intense focus on the patent, absolutely. You may be assisted by the common general knowledge, but at some point you've got to say, well, what is this core?
And just pursuing it for a moment, so suppose as a matter of construction, claim 5 refers to fingers with
Yes.
lower edges. And suppose one deduced, well, the point of this is to achieve the objectives explained earlier, but without narrowing the bag.
Yes.
Now, if that were what one deduced, that the idea was to achieve the aims without narrowing the bag, how would the inventive concept differ?
Well, if one's decided that the inventive concept is narrowing the bag, then that would probably appear in the formulation of the inventive concept. But one would drop the reference to the fingers, because then the fingers would just be one example of how you get there.
Well, sorry, my understanding is that the idea is that you would achieve something that doesn't just involve narrowing the bag.
Yes.
And you do that on the face of it by having fingers. So if claim 5 refers to fingers, where is the inventive concept different from fingers?
Well, one would conclude that, well, the language of the claim is talking about fingers. Absolutely. But as Lord Neuberger said and Lord Kitchen said, the fact that the language of the claim would exclude the variant isn't the answer. You've
No, I
got
see
to go
that.
beyond that.
But what would it be that wasn't narrowing the bag?
Well, I can tell you the answer we actually did give.
Yes.
And, well, we're just about to get there, actually. It's 104. It's Judgment 104, page 139.
But isn't that consistent with just narrowing the bag?
Well, it may be consistent with narrowing the bag, but what we've done, I mean, just looking at 104, this was our answer to the question. We say it's the use of weld portions forming part of the peripheral weld, okay? So we're not junking the whole claim, we're taking part of it. In an ostomy appliance, all the type specified, in preventing bulging and or sagging of the appliance during use, but it contains waste and or ensuring the force acting the appliance as a result of the waste is distributed relatively evenly along the length of the appliance. So what we did was, we've taken the word weld portions, and we say they've got to form part of the peripheral weld. That's why we get that from the claim.
Meaning that they can just be part of the shape of the bag.
Yes, we're part of the peripheral
protruding.
weld. Yes, well, I mean, they could either protrude or they could be part of it.
No, quite. But on your case, protrusion is not necessary. You can just be how you shape the bag.
So protrusion of the weld portions.
Well, am I misunderstanding? My understanding was you say, well, there doesn't need to be anything protruding. It's just a matter of how you shape the bag.
Well, no, there's got to be weld portions there. You've got to have weld portions which form part of the peripheral weld. To answer that question, we're relying on both lobes and waist. That's the end of the line, and the waist is part of the peripheral weld, whereas the lobes aren't. There's something additional to it.
Yeah.
I mean, that's why we have forming part of the peripheral weld in there. But that's language which we say, you know, it can be extracted from the claim. But the main thing we've done is emphasise what the purpose of it is doing. Because we say that's the problem underlying the invention. Well, the problem underlying the invention is the preventing bulging, sagging, uneven distribution of force. And actually, we're perhaps jumping slightly ahead here. If you look at my learned friend's inventive concept, it's really not that different, apart from he wants the words downwardly in there. Because we'll look at...
He wants to extend away from the periphery, which presumably is crucial.
He wants that. But in terms of what they meant to do, is Roman 3, the weld portion extensions achieving anti-bulge functionality, accepting that. And 4, insofar as any different from anti-bulge, the weld portion extensions achieve anti-sag. And finally, the even distribution of force. So actually, there's quite a lot of agreement here. It's just that the disagreement focuses on, obviously, he emphasises downwardly.
And extending.
And extending, yes.
Because just picking up something, continuing a question that was just asked, the waist bit doesn't extend beyond the periphery, does it? Isn't it just the shape of the periphery?
Yes, but when we look at it, it does actually direct the waist in.
But that's a different point.
Yes, yeah, follow that.
It doesn't extend away from the periphery.
Well,
it's just the shape of the periphery.
There's actually a short point answer to that. Well, it extends away from where the periphery would have done had it not been for a bend.
That's different.
Yeah, I follow that. It's a different point. But, what I was saying is...
It doesn't actually extend away from the periphery, given the shape that the bag then has.
Yes, I follow what I was saying. Given the shape the bag then has, it's not extending away from the shape it then has. But there is a bend which would not have been there but for the presence of the waist, and that was the point I was making.
Yeah.
So I can just go
I'm
back.
so sorry, Mr. Campbell. Can I just ask you another
Yes,
question,
of course.
which arose out of something that was asked just now? When you're looking at the inventive concept, you say you can't look at the independent claims, but you would accept that you look at the rest of the description and so on.
Yes,
and in fact, that's an important part, isn't it, of what you look at.
Correct, but then the claims and the description have got different functions. The description is telling you how the invention works. The claim are defining different monopolies.
But the description is, as I understood it from what you were saying, an important part of working out what the inventive concept is.
Yes.
Yeah, thank you.
Well, I think I've probably said enough about this, but the point, my learned friend's fifth point about can the independent claim Y have an effect on the scope of independent claim X, that's what I was asked. But and I've said that it would be a real problem for patentees if you change X and inadvertently changing Y, even with no changes. I've made that point. But which way would this principle go on the facts of this case? If my learned friend's right, some of the claims mentioned downwardly, some don't. does that suggest that downwardly is essential, or does it suggest downwardly is not essential? And we say that's just one of the difficulties if you accept this principle. Which trumps which? So we say it's just a dangerous principle. And I don't believe there's any authority for Malone and Friends' proposition that use different claims, independent claims. There's plenty of authority about subsidiary claims.
My lords, I know the jury will hold the fort, but can I just be excused for a couple of minutes?
Yeah, certainly.
Well, shall I carry on then?
Carry on.
Yes, okay. Well, yes, well, I've pretty much finished this point on the law. The only other point of law is a question of whether there's a presumption in favour of the patentee on the third actavis question. Now, we submit there's no presumption either way, there just isn't. But the only reason you get to actavis third question is if the patentee has won the first two questions. It's got an answer of yes, I'm going to say no material effect, and two, obvious immateriality. So the nature of question 3 is whether it negates the effect of the patentee winning these first two questions. It's not as if there's a presumption one way or the other. And it's not suggested in the case law that there is any such presumption. Now, I've already touched on this, but the way the judge deals with inventive concept is indeed 104 onwards. And the judge correctly sets out our inventive concept at para 104. I've drawn my Lord's attention to that. As far as Pelican's formulation is concerned, the judge actually edited it to remove Pelican's assertions that ModaVi doesn't have these features. I would like to show the actual pleading, and there's only 2 points on it. This is one and there's another one. We'll only do this once. If my Lords go to still more bundle, tab 15, page 178. And just in terms of background, para 12, he denies our formulation of inventive concepts. But para 13, he sets out the defendants. And the only point here is that, as the trial judge noted, they refer no less than 5 times to the nature of the infringement. And we say that that is significant because it does show that they've used the details of the infringement to formulate their inventive concept, which is wrong in law. And the only other point on this is to show, well, what was the scope of the validity attack and what did it say about common general knowledge? If I always go to the counterclaim on page 181, we see that the whole, I mentioned earlier, the raft of attacks that were made on validity, which all failed apart from anticipation of claim 8. But in para 27, the lawyers will say, well, there's 6 different citations relied on at one time or another. Hannon, Chang, Grumschwensen, Falconer, Esteem, Flux, Convex. That was for claim 8 novelty. And para 29 on the next page, page 182, there's actually 2 more relied on at one time or another. The new ones were Wheaton and Dansack.
Sorry, I'm mystified. Why are we looking at the counterclaim when we're talking about inventive concept?
Yes, the landing point of this is, Malone Work Friends wants to run a squeeze on common general knowledge, and I want to make the point that there was no pleading attack of validity based on common general knowledge alone. There were lots of other validity
Sorry,
attacks.
I don't understand the point about a squeeze. I'm mystified. How does that come into the case?
Well, as part of Malone Friends' argument on inventive concept, he wants to
Sorry,
say...
where is that? I haven't picked that up at all. Can
Well,
you tell me what you're referring to?
what I understand
the
Malone
relevant
Friends...
passage, because I haven't picked that up.
Yes, he says there is some sort of squeeze on common general knowledge in his appeal skeleton argument. See para 45 of Malone Friends skeleton, page 71, for instance. So that's what he's saying now. And all I'm trying to say is no such argument was ever pleaded. They didn't even rely on common general knowledge alone at first instance. They had, as I say, these 8 different attacks instead.
Right, I see. Thank you.
The judge's findings about wasted bags, I took my lord to them and showed how limited they were. Okay, well that's enough about the learned friends. There was no Formstein defence pleaded here either. Now, coming back to the judgment, paragraph 6. This is the judge's reasoning. Now, in paras 106, 107, 108, the judge is making various observations about 106, the problem which the patent addresses. We agree with that, lines 2 to 3. And then he talks about the series of appliances and mentions this as well. And then judgment 109. As I've said, the performance of all these appliances is relative to some unspecified version of the bag. This makes the concept hard to distill. It's not entirely clear what the judge means by that, because it's true that none of the claims of the patent is expressed in terms of comparing relative performance of the claim bag to some other bag. That isn't done. And if that's all he means, yes. But both of the competing formulations of the inventive concept before the judge, and indeed the formulation the judge eventually preferred, refer to the use of the weld portion to reduce sagging, bulging, and uneven distribution of force. And if the judge means, well, that's relative in that it's reducing rather than eliminating these problems, we understand that. But it's not clear why the judge described the concept as hard to distill, because the parties had distilled the concept in 104 and 105 on the previous page, and we'll see the judge's approach comes between the two. And if we just, the judge's own inventive concept is 110, and we'll see he takes elements of some elements of ours are not entirely, and some elements of the other one. Ostomy appliances, weld portions additional to the periphery of the appliance. That's the first point, additional to, which are placed so as to minimize bulging outwards or downwards or pulling at the wafer as the bag fills in use. So he's accepted the function there. And then he says again, the welds are additional to the periphery. And then finally, the inventive concept is not simply a bag of a different shape. But what the judge has said here twice in 110 is he said that the inventive weld portions have to be additional to the periphery. And I showed my lords earlier in paragraph 59, he said it could be additional to or part of. And it's not clear why he's defined the inventive concept narrower than what he concluded the claim to be in judgment 59. And the judge's construction would exclude weld portions which do reduce bulging, sag, and uneven distribution of force, but which are part of the peripheral connection, even though he held that was part of the claim. So we say the judge
Is that a fair reading of what he's saying? Again, reading this paragraph as a whole, and particularly the last sentence,
yes.
He seems to be saying that the mere shape of the periphery isn't enough to be part of, a change in the shape of the periphery isn't enough to be, isn't the inventive concept, sorry. And when he uses the word additional to, he's not necessarily saying that it's separate from the periphery. It might be part of, in the sense of joined to the periphery, but it's something more than just the peripheral weld itself.
I think that what he must be saying here, yes. But the point is it's inconsistent with what he previously construed the claim to cover. The claim covered additional to or part of, but here he's just gone for additional to. So I'm agreeing with my lord, but I'm just pointing out it's inconsistent with the judge's earlier finding. But the last sentence, the inventive concept is not simply a bag of a different shape. Well, yes, no one was saying it was just a bag of a different shape.
I think I see what he means. Maybe that's because I don't understand it either. But he means it's not just some of what you wish to achieve. You could achieve just by having a narrower bag, but that's not what we're talking about. We're talking about something different.
Well, that may be what he means, but it's certainly not clear that's what he means. And now the judge wasn't. Can I say something else? The judge wasn't obliged to accept either of the parties' formulations. It was a question for the judge. But both sides were setting out the inventive concepts, like saying in 104 and 105, and nobody was saying it's just a bag of a different shape. So whatever the judge is saying, what would that? Is that a reason to dismiss 104? Is it a reason to dismiss 105? It's not entirely clear what it would be. But if it's just a bag of a different shape, that would ignore the effect of the well portions, which was agreed.
I'm not sure. Might your well portions just change the shape on your case?
Yes. But the well portions have the effects that we've identified in our inventive concept.
Well, the obvious, I mean, as shown in the diagrams, which I know are not necessarily determinative, they protrude.
Yes.
But if well portions are simply part of the periphery,
Yes.
without protruding, well, they change the shape.
Yes. Well, they have changed the shape, but they're not quote, simply changing the shape. They're having an effect because they change the shape.
And he's saying it's got to be more than just changing the shape.
Well, if he's saying that, then yes, we could agree on that. Because you've got to have something which is well portions, not well portions which deliver the three benefits of the pattern, the three related benefits. You've got to have that. And that's perhaps a different question as to whether, I mean, does that involve changing the shape? Well, if it does, then yes, I see what he means. And does the judge's view at 110 actually, is it based on any of the observations made in 107 or 108 or not? And it's not clear really if he says that. He doesn't say it is. Because that 110, he might have said, in support of this, I rely on the fact that all these appliances mentioned in 107, 108. But if my learned friend, he does support the judge's approach to what he calls the five principles. So if the judge relies on 107 and 108, then my learned friend would say
Well, how do we know that the judge did apply the five principles?
That was the point of
they were advocated before him, but he doesn't refer to them.
Correct.
And it's not immediately evident that he's applied all five.
I entirely agree, my lord. I was just responding to my learned friend's point.
I mean, and indeed, if he had applied all five, one would wonder why there would be a need for the respondent's notice on inventive concept.
Yes. But I think my learned friend is trying to have it both ways with respect. He's trying to say, oh, well, I've got this fifth principle that you look at all the other claims to establish the inventive concept of claims 5, 8, 20. And my learned friend's also saying the judge approached it in the correct way.
Well, I'm not sure that's right, is it? Because, I mean, in this court, as I see it, it's common ground that the judge was wrong on the inventive concept. You attack it with your ground 5,
Yep.
and he attacks it with his respondent's notice. So neither of you is actually supporting the judge on inventive concept, which may be a reason for concluding that he's wrong. I mean, of course, it doesn't compel the conclusion that the judge is wrong. But you are arguing for 104, and in essence, the respondents are arguing for 105.
Correct.
So those are the battles. But then there's the separate question, well, what principles does the court apply in deciding between those rival contentions?
Yes.
And your point on principle 5, as I understand it, is that actually it's rather contradictory of the respondent's case, because the respondent's case is that the right level of generality is the level of the claim, and you agree with that.
Yes.
And you say, as I understand it, if the right level of generality is the level of the claim, then it can't make any sense to look at independent claims that have a different scope.
Correct. Yes. That's it in a nutshell. And then the only question is, well, which way does the point go in the facts of this case? And
Indeed.
did the judge actually look at all the other claims and reach a conclusion set out in 110? Or were paras 107 and 108 just background? But either way, my lord is right. And I should say, we won on the lobes on the judge's view of inventive concept anyway. When I say we won act havers Q1 and 2. We didn't win act havers Q3.
Yeah.
And finally, 111, judge says the patent doesn't disclose any principle or method to address the problems it identifies. Instead, the patent discloses a series of particular appliances that employ welds additional to the periphery. Again, that's right, but this might have been a place to mention the agreed common ground between the experts as to how the weld portions worked, because that in our submission was both a principle and a method by which the weld portions address these problems. And for that matter, it would have supported the judge's own conclusion, at least in part, at 110. Now, before going into the evidence, I'll make some brief comments about my learned friends. I actually alluded to this already. My learned friend has a respondent's notice on the inventive concept when he seeks to rely on findings that were never made about figure-8 bags. I've shown my lords what findings were made about figure-8 bag has nothing to do about how they inherently prevented bulging and or sagging and or uneven distribution of force, and the respondent's notice doesn't invite the court to make any such finding now. That's as much I want to say about inventive concept, and I was now going to turn to the evidence before the judge on infringement, which I'll take in a slightly different order for reasons I'll explain. Now, one useful starting point is what exactly is the direction of the slope in the region of the waist and lobes. And we can do this quite quickly because there's some helpful diagrams in the judgment. And if the lords go to page 141, I'm sure the lords have seen this, but that's a diagram of the waist, and the direction of the weld, that's the W-A-I-S-T, shown in red. The direction the weld would have taken but for that change is in green, and the blue arrows indicate there's an inward slope that points downwardly towards the bottom of the bag. And these blue arrows, it is fair to say, also show where a waste, W-A-S-T-E, flow. Now, we'll see from this page that Pelican's argument as to why that doesn't extend downward depends on constructing various artificial lines shown in red arrows in Judgment 117, that's the diagram. And we would say that these are merely geometrical constructs which don't relate to anything of interest in the real world. And one of the artifacts of this approach is that the closer you get to the bottom of the bag, the more the geometrical constructs point upwards. But these geometrical constructs, they're certainly not taught in the patent. And we would say, well, why does it matter whether you can do what appears to be done here? Draw a dotted red line at a tangent to the midpoint of the waist or lobe. That's the first dotted line they draw. And then draw a solid red line which is orthogonal to that tangent. What's that actually telling you?
Is it the axis which is approximately halfway through the weld?
I think it's orthogonal to that axis, actually. I think the axis which would go halfway through the weld might be the dotted red line rather than the solid one.
Well, going from the outside of the periphery.
Yes, it's clear at bottom right, bottom left, or bottom right. So you can see these dotted red lines.
Well, that's the line of the periphery, isn't it?
Yeah, well, it's...
And so then are these lines not the approximate? If you were drawing the shape of the weld, can't really see it on the, so well on the waist, but on the lobe. Is this not the approximate halfway axis?
Well, that might be what they would say it is. But otherwise, it's just a geometrical construct defined in the way that I've indicated. And what this doesn't do is it doesn't think, well, where is the waist going? What is the function of this particular feature, whether it's the waist or the lobes? And what we'd say the function is, well, the function is the diagram at the top of the page, blue lines, that's showing where the waist goes. That's the important thing. It's the way in which the upper edge directs the waist, W-A-S-T-E. And if I want to turn the page to page 142, this is what happens at the lobes. Again, you've got the red line, which is where the weld actually is. Green line, not as important here, that's just where it would be had it not been for the lobe. But the blue shows the direction of flow of the waist, W-A-S-T-E. We'll come back to 119 in a minute, but that's what the importance of the diagram is. We rely on the blue arrows and they rely on the geometrical lines in 117. Anyway, that's just oriented to what we're actually talking about. What was the evidence before the judge relied on in support of infringement? I'll come back to PPD later, but I will pick it up at, I'll pick it up at the expert evidence, which is para 69 to 70.
Well, just before we get into the details, can you help me on this? What's the relevance of this? I mean, there's no dispute as to how the ModaVi devices are constructed. And we can see them, see this for ourselves. And the diagrams are certainly helpful in understanding the arguments.
Yes.
But once one's construed the claim and understood how the device is constructed, that's it, isn't it? You apply the construction to the device as constructed.
Yes, that is our submission. And that's why.
So what's the relevance of the evidence?
I think the evidence probably goes to the Actavis questions, first question.
Right, okay. But stage one is infringement of a novel interpretation.
Yes. And we say that follows from the arguments I made on construction and just what one can see in these pictures.
Exactly, right. Okay, so that's fine.
Yeah.
But when we then go on to infringement by equivalence, your answer to my question is, well, it goes to the first question, but why? I don't understand that. It's the inventive concept of the patent. It goes to whether it achieves the same result in the same way.
Yes.
But again, why? Just help me on that.
Well, the short answer to that is it's judgment paras 123 and 126. 126 is where the judge found, as a fact, that the lobes did answer Q1 the same. They did give the material the same effect, materially the same way, on his formulation of the inventive concept. On judgment para 123, he came to the opposite conclusion as regard the waste. He held that they didn't. But that's the landing point in this argument. That's the only reason we're looking at all this evidence. Do the lobes, in short, provide the same three benefits of the invention? Anti-sag, anti-bulge, prevention of uneven distribution of force.
And to be clear, you, so far as answering the first question is concerned, you accept that the expert evidence is admissible and relevant on that question?
It is, but the actual expert evidence was, well, it was talking about the experiments for the main part, and what deductions could be made from there. The expert evidence also went to what's the mechanism by which it works.
Yeah.
But they're not going to the meaning of words, if that's what my lord is saying, or what the claim language means, or what the inventive concept means.
No, I've now understood the point. I just wanted to be clear.
Yeah. Well, anyway, the expert evidence starts at 69 to 70, but that's just saying points that were now familiar to my lords about what the effect of the welds are. We then come to the experiments, and there's three. I'm going to I'm going to rely on the judge's conclusions about the experiments. There really are three sets of experiments the judge found to be relevant, not to fight every detail of the experiments all over again, but I do need to show my lords what they were. Now, as the judge says at para 72, both sides carried out significant numbers of experiments, and there weren't any standard protocols, so the party had to devise them. Now, the first section is Salt's experiment, that's my client's experiments, 75 to 78. And just to summarise, what I actually want to do is get to 79, but to summarise what the experiments were, we had one bag, as shown on the left on diagram below 75, and one is shown on the right. And the one on the left has got waist and lobes, and the one on the right doesn't have waist and lobes. And we omitted the C-shaped weld as well. And we then performed various experiments on them, and one of which was to fill it up with 350 mils of water and image to show what the perimeter looked like. And the results are shown in paras 77 and 78. And there's an enlarged photograph at the top of page 132. So that was Salt's experiment. And essentially what we said is that the red bag, which had no welds, the red had no welds, sags more than the yellow one, which has welds.
So this is the base of what we see in the right-hand
Yes.
picture at the bottom.
They're all
of
super.
diagrams at 131.
Yes, they're all superimposed. And I think top of page 132 is just enlarged version of the bottom of the three pictures on the right. Sorry, the top of page 132 is an enlarged version of the bottom right picture on page 132. And say that the finding is just 79, quite limited finding. Ms. Anderson criticised the preparation outlines potentially inaccurate. In my judgment, it does show the different position of the bottom of the bags, but usually the different nature of the bags doesn't clearly show whether this is significant. So that was the first experiment. Now the second set of experiments discussed by the judge are also done by my clients, and these are the plaster of Paris ones. And these are shown in the two photographs at 132 and 133. And what we did here was, along the top of subject experimental variation, three identical bags filled with plaster of Paris, which had the lobes in the waist. And Lars can probably see the effect of the lobes in each of the three on the top row. And at the bottom, there weren't any waist or lobes. And our submission was that the effect of the waist and lobes, which is the difference between the ones on the top and the bottom, show that you get a more regular cast on the bags in the top row compared to those in the bottom. And the judge says, in the examples shown, Salt's nose experiments, the ModaVi bag did appear to give a more regular cast at the upper part of the bag, as shown below, but it's not clear this is significant given the unusual material used.
Sorry, where are we reading from? I see, yes.
Bottom of para 80.
Yes.
And Lars can probably, all I'm doing is showing what the judge found for the moment. But
And just, I'm sure this doesn't matter at all, but so I understand it. Going back to your earlier experiments, that you've got the diagrams at 75.
yes,
Superficially, the bottom of the right-hand bag is lower than the bottom of the left-hand bag. Is that right?
I don't think it's intended.
Is that just because of how they're represented on this page?
I don't think it's intended to be lower, but it certainly doesn't have the lobes and it doesn't have the waist. So the bottom half has got a greater volume. The judge says that in para 76.
So the overall shapes are the same size, are they, in reality, even though they're not on this page? Or maybe they are on this page.
Well,
it's not apparent to me they are on this page.
Yes, the second sentence is 76. The right-hand bag, that's the one we're using to investigate, has a greater volume. It does have a greater volume.
But is that because it comes down lower? Or
Well, the judge doesn't say so.
No.
I'm tempted to say yes, because that's the way it looks in the diagram.
But that may be the representation rather
Yes.
than the reality.
But the right-hand bag, it does have the greater volume, but we filled them with equal amounts of water. And then, as the judge says, when they're filled with an equal volume of water, the fill line in the second bag would be lower than in the control when we're trying to investigate.
Yeah.
I mean, the point about these experiments, I don't think anyone's saying any of them are perfect. It's a question of what you can gain from them.
Yeah.
But to conclude, on 79, the judge did find that the first lot of experiments showed the different position at the bottom of the bag. In other words, the red one, which has got no wells, does sag a bit more. It's down into the left. But he says, don't know if that's significant. And then returning to the plaster casts, perhaps a simpler one visually here. The top three are all the same. They've got lobes and waste. The bottom three don't have lobes and waste. The top three are all supposed to be identical to each other. Bottom three are supposed to be identical to each other. And the judge says the ModaVi did appear to give a more regular cast at the upper part of the bag.
Yeah.
But he says that not clear if it's significant given the unusual material used. Well, the judge is entitled to say, I don't think it's significant for reason X, Y, Z, but it's not clear why the choice of material, plaster of Paris, would have made a difference. There's no explanation given in the judgment as to why that would be so. And then the pictures over the page are just the same thing, showing it in different orientation.
Sorry, can you help me? What's the point of that observation? Because you don't have ground of appeal attacking the judge's assessment of the experiments. So we have to take the findings as they are, don't we?
Absolutely. But all I'm doing is there's material on which the judge could properly rely for his finding of fact about the lobes, the experiments showing the effect of the lobes in terms of anti-sagging in para 126. I'm not asking my lord to retry this. I'm just showing what was the basis for the judge's view. We'll see the judge refers back to the experiments. And the third line of experiments actually the learned friends, and that's para 81. The judge refers back to these as a part of his judgment. And they require just a bit of explanation. Now, Pelican did lots of experiments, of which these are only some. The bottom left, below para 81, is the Pelican ModaVi. That's the commercial product, showing partially filled with waste. The one on the right, again, is my client's commercial product. So we say that's just irrelevant. Now, that shows the front view of the commercial product. But as the judge says at para 81, some of the experiments included the ModaVi inversions of that bag without lobes, mod A, without waste, that's what he means, mod B, and without both, mod C. I could take my lord to the full explanation of this, but it's actually common ground what they actually are. It's all explained by Anderson 1, paragraph 267, subbundle 6, page 109. But I'll just explain to you what's shown on page 134 at the bottom. The sequence of 5 at the bottom is the one on the left at the bottom of the 5. That's their commercial product. The one to the right of it is what Pelican made called a prototype. And as Ms. Anderson explained, don't need to go there, this was essentially the same as the commercial product, but minus things which didn't matter, such as the filter. And he did that as a control. And then mod A, which is the third one, is without lobes, as the judge says. Mod B, the fourth one, is without waste. And the fifth one is without both, mod C. And the judge later refers back to this, but others can probably see from inspection that mod A, which is the one without lobes, noticeable sag in the bottom of it. And the same for the fifth one, which doesn't have lobes or waste. But there's less sagging going on in mod B, which is the one that lacks waste. Now, the judge does refer back to these in support of his submission that the lobes, in his view, did make a difference, but the waste didn't. Now that's the 5 pictures from the front, and over the page there's the same 5 shown from different orientation. So going from left to right, one is the commercial product, one is the prototype, which is the same but it doesn't have a filter, for instance. The third one is no lobes. As we would say, there's a lot of sagging going on there and bulging. The fourth one is no waste, and the last one is neither waste nor And so that's the actual experiments. And then para 84, judge is largely in agreement with what the experiments shows. And the conclusion at 89. That's the most important. In my view,
I found this passage quite hard to follow. Can you help me? Because at paragraph 85, the judge says, Ms. Anderson says the well portions of the patent, and then goes on. So what's the judge talking about here? Because I'm struggling to understand whether this is a discussion of the respondent's experiments, and if so, why? Because, as you've just pointed out, although there was a commercial product, most of it was about the defendant's commercial product and the prototype and the mod A, the mod B, the mod C.
yes.
So, what's...
Well, I think the frank answer is don't know. I'm not sure why the judge referred to Miss Anderson's evidence about the well portions of the patent. As my Lord says, it doesn't seem directly relevant to what's just gone before.
I mean, whether or not it's relevant, presumably it's based on something in her evidence.
Well, she did make these points elsewhere, yes. I mean, Roman 3, for instance, that's the point that we've seen a number of times.
Yeah.
And 2, this is... perhaps I'm answering my question wrongly, but if she's talking about well portions of the patent, well, yes, absolutely, but this is the judge's analysis of the experiment. So it seems out of place.
I mean, I'm looking at the evidence you mentioned a moment ago. For example, 279 at page 115. That's probably consistent with some of this.
Sorry, is it some?
Sorry, I'm on 115 of the supplemental bundle. I'm not sure I'm looking in the right place, but anyway, some of it seems to be consistent.
All right, but you see, just before we go elsewhere, can I just follow my question through? Because it bears upon the judge's apparent conclusion in 89. Because he says, experiments helpful to demonstrate behaviour that bags in practice non-decisive on the issue of infringement, talks about the presence of well portions. But the conclusion in the final sentence is this: it's hard to draw conclusions to the significance of any of these measurements or observations in the context of the patent, because it gives no guidance as to what's significant to achieving the invention disclosed. So what does this tell us about the finding of the allegedly infringing product?
I think 89 is easier to understand because he's alluding back to the fact he didn't think the patent gave hard and fast rules. It didn't give any guidance as to what's significant. So you can't say, well, the experiments show X. I can go back to the patent and see this ticks the box because the patent didn't have any quantitative figures in it. I think that's what he means, actually. Right. But he does say in 89, well, they are, as I say, they're helpful to demonstrate the behaviour. And we'll see later, he does find them helpful in answering question 1 octavis as well. The last sentence might be out of place or might not be, but I think that's what he meant. I can't relate this back to a test in the patent because there is no test in the patent.
Okay, thank you.
So that's the experiments. And the next part of the evidence before the judge was Eakin and the launch presentation. Now, I'll start with Eakin. The judge has gone straight to two important paragraphs, which are 58 and 59. But my Lord might be assisted by a little more context about Eakin before we get there. And Eakin is in the supplemental bundle at tab 21. And if my Lords have sub-bundle tab 21, page 267, we see that the diagram on the front page actually is figure 4 is reproduced in the judgment. We'll look a bit more about that diagram at the moment. And we see that Mr. Mahood is the first named inventor of all this. Now, so far as the object of this, meaning Econ, is concerned, and obviously it postdates our patent, otherwise it would be prior art. Go to paragraph 1 of Econ on page 269. As we see in the field of the invention, it's stated to be as follows. The present invention relates to a collecting device, in particular an ostomy pouch, having strengthening zones for structurally reinforcing the pouch. And that's the phrase it prefers to use rather than weld portions. In paragraph 5 over the page, we learn the problems which Econ is addressed. And as it says, as the collecting bag fills during use, the weight of the contents, this is the background to Econ. As the collecting bag fills during use, the weight of the contents can cause sagging of the pouch. As the load in the collecting bag increases, the lower part of the pouch begins to fall down on the upper part, causing the upper part to sag downwards and sag or fold forwards. The edge seams on the lower part of the pouch begin to kink and buckle, which can cause uneven distribution of the load within the collecting bag. As a result, the load on the mounting plate may become unevenly distributed, putting down more on one side than the other, which can cause discomfort. The kinked seam may also extend rearwardly into contact with the wearer's skin, which may also cause discomfort due to the stiffness of the seam. Deformation of the pouch can therefore cause discomfort to the wearer, producing an unsightly appearance, with the pouch becoming more noticeable beneath the wearer's clothing as it sags and folds, and it's therefore desirable to provide an improved ostomy pouch, which addresses the above-described problems and offers improvements generally. Now, paragraph 5 does mention the kinked seam, but otherwise a lot of this sounds extremely familiar, we would say. It's dealing with sagging and dealing with uneven distribution of the load on the mounting plate. So that's the problems in which Econ is addressed, and also the unsightly appearance under the user's clothing. Now, turning to paragraph 28 on Econ, on page 275, it says as follows: conventionally, the collecting bag and outer cover of collection pouches, such as ostomy pouches, are only bonded together on a thin peripheral seam, suitable for closing and sealing the edge of the pouch. Bonding these layers together in other regions inboard of the peripheral seam, while not necessary to close and seal the bag, in addition to the peripheral seam, provides strengthening zones that structurally reinforce and support the pouch in use. These strengthening zones may, for example, support the bag and prevent sagging and/or assist in optimizing distribution of load of the contents within the collection bag. Forming the strengthening zones by bonding each of the front and rear parts of the cover of the front and rear walls of the collecting bag together, the lamination of at least 4 layers provides significantly improved structural support. So the term weld portions isn't used. It talks about strengthening zones. But again, this all sounds very familiar. And strengthening zones are created by bonding layers of the bag together in other regions inboard of the peripheral seam for the purpose of preventing sagging and or assisting in optimizing distribution of load of the contents within the collection bag. As I say, it sounds very similar. Now, it's with this background that we can go to paragraphs 58 and 59, which the judge has got. And it is helpful to go back to the judgment at this point, because the judge has got the diagrams above the paragraphs on the same page. I'll invite my lords to read judgment, page 92, quoting paragraph 58. I'll just highlight some parts of it. Econ is now describing what we see in figure 4. And as Econ says, the peripheral bonding region has got a first width W1. And my lords will see the W1 right-hand diagram just below the waist on the left. And that's selected to ensure a robust bond and seal between the layers forming the pouch. And then it says the bonding region 56 includes first and second strengthening zones, 58 located at the lower end of the pouch, one along the curved lower edge 57. And if we want to look at what's described as first and second strengthening zones 58, it is the lobes. And it says that in the next sentence, the strengthening regions, I don't think there's a difference between regions and words, strengthening regions 58 comprise lobes formed by undulations in the bonding region, whereby the width of the bonding region is locally increased to width W2. And the Lord will see W2 bottom left of the right-hand diagram. And then it says, as such, pouch 1 is locally stiffened and reinforced, and so on. Now, it says quite a bit more about the strengthening zones 58, picking it up towards the bottom of this paragraph, 6 lines up, at the inner edge of the bonding region 56, that's the peripheral weld. The strengthening zones 58 symmetrically curve gradually inwards from the width W to a curved peak, defining the maximum width, and then curve back outwards to the width W1. The strengthening zones therefore have an undulating, wave-like form and face substantially upward, away from the lower end of the bag towards the upper end. A concavely curved valley or bowl region 62 is formed between the two convex strengthening zones 58. So what we've done there is Eakin has explained the first and second strengthening zones 58 as being lobes, and it says there's a valley region 62 between them. Then as the judge goes on, as Eakin goes on, in paragraph 59 of Eakin, in use as the collecting bag 2 fills, the strengthening zones 58, that's the lobes, provide increased stiffness to the lower edge 57, helping to maintain its form and resist buckling. As the collecting bag 2 continues to fill, the contents are channeled to the centre by the concave valley region 62 formed by the strengthening zones 58. So that's saying the contents are channeled to the centre by the lobe. As such, the centre of mass of the lobe is maintained along the centre line BB, which prevents uneven distribution of the load across the mounting plate 8. In other words, the lobes are preventing uneven distribution of the load. And then it goes on to explain, as our collecting bag 2 fills further, and so on. I want to get the last sentence, if I may. The waist section 64 pinches inwards as the collecting bag 2 fills, further assisting in channeling the contents towards the centre of the collecting bag. And 64 is indeed the waist, the Lords can see it, which further assists the lobes in channeling the contents to the centre of the collecting bag. So that's what Eakin actually said, and the judge says at 94, Salt says that this shows that the waist and lobes direct the content towards the centre of the bag, so as to prevent uneven distribution of load across the mounting plate. And we'd say, well, that is what we say, and it's actually what the document said.
Sorry, I'm completely lost as to the relevance of all this, and it's my fault for failing to articulate my question clearly earlier. So let me have another go at articulating my question. So, can we go back to your grounds of appeal, please?
Yes.
It's Court Bundle tab 2, page 19.
Yes.
And ground 6 is your ground on the activist's first question.
Yes.
And you say the judge correctly held that the answer to the first activist's question was yes for the lobes and yes for the combination of waist and lobes.
Yes.
And then, so far as the waist alone is concerned, which is what is the focus of the ground of appeal, had the judge correctly identified the inventive concept, he would have held that the answer to the first activist's question was yes. So therefore, as I understand it, ground 6 is purely consequential on ground 5. Because ground 5, you're saying he got the inventive concept wrong.
Yes.
And in ground 6, you say, well, if he got it right, that would have led to a different answer to activist question 1.
Yes, just for the waist.
But to be clear, the point of the question is this. I'm not seeing in the grounds of appeal any attack on the judge's findings of fact when answering question 1.
No, we did think about that.
You may have thought about it, but it's not in the ground.
That's the warm-up. The Lord will have noticed that in our reply skeleton, it all comes down to para 123 of the judgment, where the judge held that when answering Octavius question 1, he felt that the waist didn't make enough of a difference to justify answering in our favour. But in judgment 126, he held that the answer to question 1 was yes for the lobes. And all I'm trying to do is support the judge's conclusion in relation to the lobes.
I see.
By what I'm looking at the moment, which is partly based on Eakin and experiments, I've shown the experiments, and now I'm showing my Lord Eakin.
Right. Okay, so you're at this stage you're really addressing the respondent's notice.
I probably am, yes.
Okay, that's helpful. Thank you.
But going back to what the judge says about Eakin, I was just on paragraph 94, and that is exactly what we did say. And it's not entirely clear whether the judge actually accepts. It's not entirely clear here whether the judge accepts that. But later on, he does rely on Eakin in relation to the law, so he must accept it to some extent. I mean, I'm going to go to this later, but if the Lord wants to go to Judgment 126, maybe that's a pithier answer.
Well, sorry, I'm puzzled by your reference to paragraph 94, because that's setting out your submission.
Yes.
The conclusion is at 96. He says Eakin is relevant and makes claims to the effect of loads and weights on its own, doesn't show infringement.
Yes. I follow that completely. The reason I'm going for this, I will just show my Lord 126, just to show why I'm doing this at all. 126, he's dealing with the lobes. He says the lobes extend inward of the periphery ModaVi bag and away from peripheral appliance. While they do not extend downwards, the experiments at Eakin show that they do affect the shape of the bag so as to minimise bulging outwards or downwards, or pulling it away from the bag as the bag flows induced. The answer for lobes is yes. And we do rely on that finding, which is based on experiments in Eakin. And that indeed is the reason why we've gone to Eakin. But my Lord's ahead of me. My Lord notes the finding at 96. And the other document is the launch presentation, which the judge summarises. But again, I'll show my Lord the document because there's a little bit more context to it. This is SB 22. And if my Lords have got SB 22, what this is an internal launch event held at Pelican, essentially to tell their sales staff, who in some cases were nurses, how they would themselves sell the product. And we see the date, Wednesday 10th and Thursday the 11th. And if my Lords go to page 309, see it was a full day event, centrepiece being the product reveal and user feedback at the centre. Page 310, one of the presenters, Mr. McNamara, who did actually give evidence at the trial. And then page 311 is the beginning of a section called Smart Structure. Page 312 says, what we heard, users and nurses wanted a pouch that filled up evenly and didn't bulge or sag. And I've emphasised the words bulge or sag. And then page 313, when it comes to appearance, Pelican ModaVi Smart Structure gives it the edge. Cutting edge design means the pouch will keep its form, structure and shape even when filled. And then the next two pages I'm going to skip over because it's 316, which has it all on one page. I mean, I'm not cheating, one can look at 314 and 315, but 316 has it all on a single page. And what this says, patent protected for the product, it's not disputed this refers to Eakin, although it was just an application at that stage, not patent. At the top it says our smart C-weld, and this is the one which the defendant's expert didn't realise was doing this, adds form and structure to the pouch, meaning it keeps its shape better than other bags do when filled. And at the bottom, our smart lobe and our closed pouch provides even more structure to the pouch. And then there's some illustrations on the next page as to how the, well, 317 isn't particularly illuminating, but look at page 318. Smart structure, here's why it makes a difference. Its smart appearance and iconic look aims to the user a great sense of comfort and confidence. A consistent shape and structure means no more bulging or clothing. And we say what this shows is that it's presented as being the smart C-weld and the smart lobe. But the reason they're there, one gets from page 312 is because users and nurses wanted a pouch that filled up evenly and didn't bulge or sag. And it makes a difference because, as stated on 318, consistent shape and structure means no more bulging under clothing. And I should say before going on that this was never a document which was disclosed because they never did provide any disclosure. We only got this document because they relied on it for their own purposes. But as we explain in our skeleton at paragraph 53, the reason why Pelican was able to avoid giving disclosure and rely on a PPD was because Mr. Justice Mead was told at the CMC that Pelican's documents didn't contain statements that the lobe sections combated sagging. And we've given the reference, we don't need to look it up, it's CMC sub 16 230 26 F to H. Mr. Justice Mead asked, your documents do not contain statements that the lobe sections combat sagging as you have defined it in the earlier paragraph we're looking at, and it refers to the relevant paragraph of PPD. Answer, yes, we are confident. One, we know what our obligations are, and we've done a proper exercise. We have not been coy in assuming a very narrow meaning of bulging and going, aha, we do not need to disclose this because we're looking at a very narrow meaning. So what my learned friend described to Mr. Justice Mead as a proper exercise was done in such a way that this presentation, nor Econ, was disclosed to us.
Is that going to be a convenient?
It is, yes.
In which case, 2 o'clock.
For April